introduce here Cristen Martinez. She has a practice in Lutz, specializing in real estate law, both residential and commercial. And she's here to give us some guidance on all these crazy things that are going on in our industry right now. So welcome, Cristen Martinez.
Do you need me to do something special with this? You can hear okay with me here? Okay, all right. Thank you guys for having me. I'm Cristen Martinez, and we are going to attempt to tackle the NAR settlement and the practice changes and what that's going to mean for the industry going forward. I'm not going to have all of the black and white answers for you here today. We're still going to hopefully be getting some additional forms and information between now and the time that these changes become effective, but we do have a lot of information. So I'm going to take you through a small procedural update as far as where we're at in the court process and where we're going. And then we're going to take a look at these substantive practice changes, what it means for you, what it means for the market in general. I am going to save time at the end for Q&A. However, feel free to throw your hand up, interrupt me at any time to ask questions. This topic I like to do more as kind of like a roundtable discussion because you guys have so many specific questions. There's a lot of unknowns right now. And so I want to provide as much value as I can to you guys. So feel free to interrupt me at any time with questions. But with that, let's go ahead and jump right in. I'm going to start with a procedural update. So there has been a fully executed settlement agreement. However, there has not been final court approval yet for the settlement agreement. And there's a process that has to take place in order for that to happen. So the first thing that has to happen is the settlement agreement required the plaintiffs in the lawsuit to file a motion for preliminary approval. That has happened. They filed the motion, and we do have an order from the court granting that preliminary approval. If I can figure this out, I want to show you that order very quickly. Can you see that? All right, perfect. So this is the order granting the plaintiff's motion for preliminary approval. And why I wanted to pull this up is because people always ask me, do you think the court's going to ultimately approve the settlement? And I do think the court's going to ultimately approve the settlement. And I think that in part because of some of the language used in the order here. Now, the court may approve it with some changes or modifications, but for the most part, I do think it's going to be approved. So if you take a look at the second paragraph of this order, the court here finds specifically that the settlement with NAR as set forth in the settlement agreement is fair, reasonable, and adequate. The court found that the class representatives have adequately represented the class, that the settlement was negotiated at arm's length by experienced counsel acting in good faith. There was a mediation that took place, pre-trial and post-trial negotiations, and that the settlement was reached as a result of those negotiations. The court also found that there's been adequate opportunity for discovery. There's been pre and post-trial motions, and that the court will likely be able to approve the settlement pursuant to the applicable rule of procedure. So based on the language in this preliminary approval, I do think we're going to see a final approval. The court expressly stated that. However, we could see some modifications based on the objections, if any, that are posed. So let's go back to our slides here. So we have the order granting preliminary approval. From the granting of that order, there's a 60-day window for interested parties to file written objections to the final approval of the settlement. There have been several objections already filed. The ones that I've read, I don't think the court's going to do anything with. The DOJ is obviously an entity that is against the express language of the settlement agreement. The DOJ's position is that they want a prohibition on the ability of a seller or a listing broker to be able to offer compensation to a buyer broker. I don't think the court's going to go that far. That's what the DOJ's position is. But there's going to be a final hearing on November 26th of this year where the court will make a determination on whether to ultimately and finally approve the settlement agreement. We may see the court rule at that hearing, or the court may reserve and rule in the days or weeks following that hearing. But that's kind of the timeline of the court's approval process for the settlement. Now, the practice changes themselves as of right now are set to go into effect on August 17th. Why are they set to go into effect before we'll ultimately have final court approval? Because that's what the parties agreed to in the settlement. The settlement put forth a timeline for NAR's implementing of the practice changes and a timeline for court approval. Those timelines don't stack up with each other. And so this is what we have. If the practice changes are implemented August 17th and the court ultimately decides not to approve the settlement, we'll just see an unwinding of those, or those new practice changes will no longer be binding. I don't think that's likely and is going to happen, but that's theoretically what would happen. So the DOJ's investigation is, they did win an appeal and they're permitted to reopen their investigation. Keep in mind that their investigation started in 2019. Things were much different then as far as the practice changes that we've already seen NAR implement. So whether they're going to reopen and fully investigate and what the results of that are, we don't know at this point. But this is kind of the procedural landscape and layout of the settlement. Now, I'm sure you all probably already know what the settlement agreement does, but there's a lot of misinformation out there, especially in different media outlets, on social media, things like that. So I'm going to take you through specifically what the settlement agreement does do and what it does not do. And that way we're working from the same page when we talk about different best practices and changes to your businesses as a result. So the first thing it does is that it fully and finally resolves all claims and future claims by or against parties to the settlement. This means that we're not going to see any more copycat lawsuits or additional lawsuits being filed for these same types of claims. That's one of the biggest benefits of settling, is whether the parties, the realtors, the MLSs, NAR, the brokers, whether they like the terms of the settlement agreement or not, at least they know what the case is and that that's going to remain the same. There's not going to be any further lawsuits challenging that by other parties. Now, of course, there can be appeals to the court's decision and things like that, but no more copycat lawsuits. Buyer broker agreements are required to work with a buyer prior to the first showing. So this is one of the major practice changes that we saw. We are going to break this down. We are going to talk about what it means to work with a buyer, when agreements are required, when agreements are not required. Cooperative commission is no longer required and remains optional. This isn't really a change, but this is specifically included in the practice changes section of the settlement agreement. Next, the settlement prohibits the disclosure of commission to cooperating brokers on the MLS or any third-party website obtaining its data from the MLS. This is another major change that we see as far as the practice changes go, and we're going to take a deeper look into that as well. And then lastly, the cooperative commission remains a choice for consumers when buying or selling a home. Again, that's not really a change, but that is included in that practice changes section of the settlement. Questions on this before we move on? All right, let's take a look at what the settlement agreement does not do. And this list I pretty much got when the settlement agreement first came out. I wanted to obtain a copy of it and read it. And so I did a Google search for NAR settlement agreement PDF, and the entire first page of Google was headlines from media outlets, 100% of which were false and inaccurate. And so that's kind of where I got this list. So the settlement agreement does not prohibit listing brokers from compensating buyer brokers. This is what the DOJ is fighting for, but this has not been implemented. I don't think it's going to be implemented. And so there's no prohibition on that aspect. It does not prohibit sellers from compensating buyer brokers. It doesn't dictate how much agents can earn. It doesn't do away with the 6% commission, which were the majority of the headlines that I saw. It doesn't dictate how agents are paid or who may pay buyer brokers. So the biggest changes that we see are the requirement for a buyer broker agreement in certain situations and the inability to advertise or communicate any sort of cooperating commission on the MLS. Everything else for the most part is staying the same, with the exception of some disclosures and things that we will take a look at as well. So as far as buyer agent compensation, this was the case prior to the settlement agreement. This is still going to be the case after these changes are implemented on August 17th. But the buyer's agent can be paid directly by the buyer, by the seller, through seller concessions, or by the listing broker. There's no change here. I just want to make sure that we're all clear that that is still the case. So when we take a look at, and the NAR's website has a very long list of frequently asked questions about this settlement agreement. So if you ever have questions, start there. Some of their answers are kind of vague. They just kind of repeat the same boilerplate answers. But I took some of the frequently asked questions from their website that I'm getting a lot and that I'm getting a lot in these classes. And this will address some of the topics that I touched on earlier. So the first one is, can buyers and buyer brokers rely on an offer of compensation that was on the MLS prior to the effective date of the MLS policy change? So here we have a property that is listed prior to August 17th. There's an offer of compensation on it. Let's say either contract is executed or closing occurs after August 17th. Is that offer of compensation enforceable? That's the question. So here's what NAR tells us. If the sales contract is executed before the date of the policy change, which we're going to use August 17th for that, the buyer broker should be able to rely upon the offer of compensation even if closing occurs after the date of the policy change. So long as your purchase and sale agreement is fully executed prior to August 17th, you can rely on that offer of compensation in the MLS. However, if a sales contract is not executed prior to August 17th, the offer on the MLS will not be valid, and buyers and buyer brokers may wish to protect themselves in writing with the listing broker or seller through a broker agreement or by including the offer of compensation in the sales contract. So if you have a contract that's signed prior to August 17th and it closes after that date, you are good to rely on that offer of compensation. However, if you have a listing that goes live prior to August 17th, but the contract is not signed until after that date, you need to execute a separate agreement with whoever's paying your compensation, whether that be the seller or whether that be the listing broker, in order to enforce that. And why this is important is because how it works right now is when an offer of compensation is made on MLS, that is an offer to any buyer broker that brings a buyer who's ready, willing, and able to purchase the property. Once you supply that buyer, there's a binding agreement. There's offer acceptance and consideration between you and the listing broker to pay that compensation. After August 17th, there can be no more offers on the MLS, which is why this date is important, especially when it comes to transactions that some of the transaction occurs before that date and some of it occurs after. Am I being clear on that? Questions? Anybody? All right, lots of heads nodding. So that's a good sign. All right, and then the next big question that I get very often is, what does it mean to be working with a buyer? And this term is important because you as a buyer broker are required now, as of August 17th, to have a signed buyer broker agreement prior to showing a property to a buyer that you are working with. So what does it mean to work with a buyer? Here's what NAR tells us. The working with language is intended to distinguish agents who provide brokerage services to a buyer, such as identifying potential properties, arranging for the buyer to tour a property, performing or facilitating negotiations, presenting offers, or other services for the buyer. So it's looking to distinguish kind of your traditional services that you would provide to a buyer from agents who simply market their services or just talk to a buyer, like at an open house or by providing an unrepresented buyer access to a house they have listed. So the distinction in the line here, it's not black and white, unfortunately. But the distinction is, if you are merely providing access to a property to a buyer or a potential buyer, that could be at an open house or that could be to an unrepresented buyer who reaches out to you directly, you are not working with that buyer and you do not have to have a signed buyer broker agreement. If you provide access to a property and you answer some general questions about the property, you are not working with that buyer and you're not required to have an agreement. Anything more than that, I would strongly suggest you get a buyer broker agreement signed. If you are going to provide the standard as is contract to the buyer to allow them to fill it out and submit the offer, that to me crosses the line. And I say to me because, again, we don't have a black and white line. I'm giving you what, in my legal opinion, is going to be best practices for you to make sure that you're protected. If you are advising the buyer on how to fill out the contract or filling it out for them, or they're sending you an email, here's what I want to offer, can you put it in the contract, and you're preparing that contract, in that scenario, I would get a buyer broker agreement signed. Now, keep in mind that just because you have an agreement with the buyer doesn't mean the buyer has to pay you anything. you can define your relationship. You can say, hey, I'm going to provide the standard contract and I'll help you fill it out. I'm not doing anything else. You don't owe me any money for doing this, but this agreement is going to memorialize the way in which we're going to work together and whether any compensation is due. So buyer broker agreement doesn't mean in the traditional sense, like what we're used to, the standard documents provided now, where you owe a full range of services and duties to a buyer. It can be none of that, it can be all of that, and it can be anywhere in between. NAR continues, if the agent is working only as an agent or sub-agent of the seller, then the participant is not working with the buyer. In that scenario, an agreement is not required because the participant is performing work for the seller and not the buyer. So another point and kind of best practice on this one is just because you're not required to have anything signed with a potential buyer doesn't necessarily mean you shouldn't. So I'm a big fan of using no representation agreements. I think we're going to be entering into a climate in a market where we're going to see more unrepresented buyers and sellers. That means we're going to see more confusion, more opportunity for disputes. And when there's a dispute, in my experience of being a litigator, I defend and sue people in the context of real estate transactions, your risk of liability is going to go up because when somebody's in a dispute, whether that be the buyer or seller, they want to sue anybody and everybody they can possibly sue. And agents normally come up in that conversation. My answer is not always, yes, you can sue the agent, but the question is almost always asked. So you want to make sure that you're doing what you can to be as clear as you possibly can with the buyer or a potential buyer. That you are memorializing that in writing. Verbal statements can be enforceable, but you don't want to rely on that because the buyer is going to hear something different than what you're stating. So just because you're not required to enter into an agreement doesn't mean necessarily you shouldn't. And we'll talk about buyer broker agreements in a little bit more detail in a few minutes. All right, next, can a listing broker communicate offers of compensation on a broker website which has an IDX or VOW feed? So this question comes from the practice change that states you cannot offer cooperating compensation on the MLS or on any third-party website that gets its data from the MLS. So that's going to be your Zillow, your Realtor.com, those sorts of websites. However, if you have a website for your brokerage or for you personally as an agent, or you have your professional social media pages, you can advertise offers of compensation in those locations. You can do mass emails saying, hey, I got a new listing, and guess what? We're offering 3%. You can advertise it in many places, just not on the MLS or any third-party website that gets its data from the MLS. So one area of confusion, and I'm not an agent, so I don't have a website like this, so you guys would know more than me, but a lot of agents have a website that have these feeds that does pull some data from the MLS. So are you prohibited from advertising or communicating an offer of compensation on that type of website? NAR is saying you can offer that on your personal website, even if you are linked with one of these feeds. So NAR says, yes, MLS participants may augment MLS data or data feeds with offers of compensation to buyer brokers or other buyer representatives for only listings of their own brokerage. So that's the caveat there, is you can't just create your own website that pulls from MLS. It has to be limited to listings that you personally have or that are within your brokerage. Questions on this? Okay. All right, so for the next several slides, I put down some kind of practical effects or changes that I see, some kind of talking points. So there's been no questions or comments yet, but if you guys want to kind of open up discussion, I've just kind of put topics up here that I'm seeing and that I think are going to become important so that we can kind of have an open discussion about them. And then we're going to specifically go through the requirements for buyer broker agreements. So negotiation of commissions up front and the payment of commissions at the time of contract. So this is a change that we are going to most definitely see because before you can work with a buyer and show them properties, you have to enter into a buyer broker agreement. And in looking at the requirements of the buyer broker agreements, which you guys are not going to like, these requirements force you to have the money conversation upfront with them. You can't just say, hey, I'm going to represent you. Let's wait and see what the seller's offering or what the listing broker's offering, and then we can talk about money if we need to. That's not an option for you. So these negotiations between you as a buyer broker or buyer's agent and your client are going to happen upfront. And here's why. So let's take a look at the requirements for buyer broker agreements. Number one is the agreement must specify and conspicuously disclose the amount or rate of compensation. This one is pretty obvious. I do think we are going to see new standard forms. Florida Realtors has promised us new buyer broker agreements, new listing agreements, and other compensation agreements. I don't know what that means, but hopefully we will find out shortly. So those are going to comply with these requirements, but the rate of compensation or the amount of compensation has to be conspicuously disclosed in the contract. What does conspicuous mean? It means it has to stand out from the other text in the contract. So it's set out by a box, it's bolded, it's all caps, something like that, so that that text stands out from the rest of the text. Number two, the amount of compensation must be objectively ascertainable and may not be open-ended. So here is where things get difficult. Here is where you are prohibited from saying, you owe me whatever the listing broker is offering. If they offer me 0, I'll take 0. Or, you owe me 1%, but if the listing broker is offering 3%, I get the 3. You cannot put that in your agreement. So the amount or the rate of compensation has to be objectively ascertainable. So it cannot be dependent on some future unknown event, like what the listing broker may be offering you. Now, you can put in things like an hourly rate, or a range. So I'm going to charge you between 2.5% and 3.5%. However, in the buyer broker agreement itself, you have to identify under what circumstances the compensation is going to be 2.5%, 2 3/4, 3, 3 1/4, or 3.5. Like, you can't just leave it open-ended and say, we'll figure it out at the end. So an example can be, if I show you between 1 and 5 homes, you owe me 2.5%. If I show you 6 to 10 homes, you owe me 2 3/4. That's just an example of how you can set a range, but how specific you have to be, because the buyer's going to know exactly how much they owe you, depending on how many homes they ask you to show them. So it can be an hourly rate or a range, but you have to have language in there specific enough so that the buyer can figure out what they're ultimately going to owe you. Does that make sense?
And they only owe if they go to contract and get their offer accepted.
So yes, so the payout is going to work the same as far as when you are paid. So if you're procuring calls or if you close, obviously that's when, now you can alter that in your contract. So I'm getting lots of calls from brokers asking me to draft like very creative and customized buyer broker agreements. So one thing I'm seeing is like kind of like an a la carte menu with flat fees. So like each showing is this amount. If you want me to do your contract, it's this. Each addendum or amendment, it's this. So those amounts you can put in your contract are paid out like as I earn them, or you can put they're paid out at closing at the end. So you do have some flexibility there, but at least the current forms that we have are drafted, that you're paid at closing, or if you're the procuring cause, if the buyer cancels for no reason and breaches the contract, you're still entitled to your commission. Any other questions, thoughts, comments on that? All right. Oh, yeah.
On the contract, when we write it, there's a line right now that says what the seller's paying. We can still write the contract and put on there buyer's agent commission 3%, correct?
What do you mean there's a line for what seller's paying?
On the contract, it tells you the fees that the seller's responsible for, and then.
Oh, on the listing agreement.
No, it's not on the first one. It's like page 3 or 4 of the first.
Like the closing costs.
Oh, on closing costs. Yes. So right now, and then of course, as we get up to August 17th, if the seller is going to be paying you a portion or all of your commission, that needs to be in the purchase agreement itself. So you could put it there, you could put it in additional terms.
And it doesn't matter how you have your buyer broker agreement written, if you write your contract.
No, it does.
Is it gonna matter how, like, let's say that I have a buyer broker agreement at 3%. Let's say that the listing agent's only offering 2% on the MLS. We don't see that. I can still write my contract. And on my contract for what the seller's going to pay, I can put 3%.
Correct. Yes.
is there specific language that has to be used, because I've heard conflicting information on this, as to how we specify that concession in the admin's contract?
So legally, there's not like certain verbiage or words you have to use. It's not, I would either recommend you wait until the new standard forms come out. I'm hoping a revision to the purchase agreement comes out as well, so that when the seller is paying you, there's standard language there that you can fill in the amounts for that. If not, I would suggest you have template language professionally drafted that you can just throw into your contracts as they come through. So, I mean, aside from just making it binding and enforceable, like in a legal sense, there's not specific words or verbiage you need to use. But as of August 17th, you'll be able to put that in the contract itself now, and you should, because that's the only kind of way you're going to create an enforceable relationship between seller and you as the buyer broker.
So if let's just say it's 3% on our buyer broker agreement, but the seller may offer 2%. Is it now the buyer has to come up with the 1%, or can we just take the 2%?
So with your agreements, you have that option. So my guess is that the new standard agreements are going to provide that the buyer has to pay the difference out of pocket. As the person that they are required to pay, you have the choice of whether you want to enforce that or not. So that goes well into the next requirement here. You can always take less than what you've agreed. However, buyer broker cannot receive compensation from any source that exceeds the amount or rate agreed to with the buyer. So you can never take more than the compensation agreed to in your buyer broker agreement. You can always take less. Now, this is problematic as well. In one of the kind of contexts that it becomes problematic is with new construction and new home builders. So if you sell, a certain amount of homes with a certain, for a certain builder, sometimes they give you bonuses or incentives, things like that. If those bonuses kick you above what you've agreed with your buyer, you cannot take them. So make sure that when you are negotiating these buyer broker agreements, you're not shortchanging yourself. You're not, agreeing to as low an amount as you would ever possibly take just to get them to sign with you, because you can never get more than that from any source. So it doesn't matter whether it's from listing broker or seller. Yes, ma'am.
So can we have multiple buyer agreements if we know we're looking at, new construction?
Yes, so you can have a different buyer broker agreement for different types of properties. I don't think we actually go through that in this one. I can pull it up if you want, but in the current buyer broker agreement, on the first page, there's an area for you to specify like the location of the property, the type of property they're looking for. So you can certainly specify it by type of property. You can also specify it by property. So, if you're sending potential properties to a buyer and they're like, I want to see properties 1 through 5, you can say, all right, here's an agreement for each one of the 5. And that can be based on different things. That can be based on purchase price. That can be based on distance that you're going to have to travel to show it. You can call the listing agent or look at their personal website and sometimes figure out what the commission or the compensation is going to be. With builders, I don't know how that works if you already know what bonuses are going to be offered, or if you don't know that until afterward, but you can certainly customize it in that way so that it's per property.
So at what point as buyer agent are you going to have the information of whether or not compensation is being offered? Should we call ahead of time? Should we?
So it depends, right? So if you're working with a buyer and you sign a buyer broker agreement and then they say, this is what I want to look for, can you start sending me properties? You're not going to know anything about cooperating compensation at that point. However, once you start identifying properties that fit with their criteria, you can always figure that out. You can call the listing broker. Sometimes they might have it on their personal website, their social media, whatever the case may be. So it kind of depends on the timing of when you are coming to this agreement with your buyer, keeping in mind that you have to have an agreement for each property before you can show it. So that's either a blanket agreement that covers all properties, or if you're going to do it by property, it has to be before the showing. So you could certainly do it to where you have time to figure that out before you enter into an agreement with your buyer. Yes.
That could have put us in a position for amendments and whatnot, to the original agreement, if there were changes, based on my 3%, seller's gonna look to, I don't wanna charge my buyer that extra percent, we have to amend those prices.
So if you agree to take less than the original, so the best way to do it would be to amend the contract. That's going to protect your buyer. It really doesn't make a difference for you because it's your prerogative whether to take less or to enforce the full amount. But this wasn't your question, but I get asked this question a lot, so I'm going to answer it anyway. If you have a buyer broker agreement at, let's say, 2.5%, and your buyer looks at a home that's offering 3%, you can't go amend it at that point to up it to 3%. Because when you have rules and regulations like this, you have to think about like the underlying purpose of it. And so that would be obviously contradicting the underlying purpose of making this rule in the first place. But if you go down, the cleanest or best way to do it would be to have a signed written amendment. Yeah.
How is the seller getting into this agreement?
Getting the buyer broker agreement. So the seller doesn't necessarily get it. I'm sorry. I would not submit your buyer broker agreement with the offer. What I would do and what I foresee happening is if your buyer, as part of their offer, wants to include your compensation as a term in the deal, I would write it in the contract. Or if it's going to be from the listing broker, I would separately say, as part of our offer, we're requesting you pay us 3% or whatever it is. Now, could they, before agreeing to that, could they require you to provide a copy of the buyer broker agreement? Yes. They can make that a requirement of their agreement, but unless they require it, I would not provide it. And I would even recommend providing just the portion, the compensation portion of your buyer broker agreement. It's not really relevant or their business what else you are in agreement with as far as your buyer goes, but that's how I would handle it. I would not offer it up, but of course, if it's going to be a condition of the agreement, then you have a choice to make at that point. Did I see a question over here that I missed? No. Okay. All right. And then we already covered this, but you can obviously customize the buyer broker agreement by property and by term. So this is also going to become relevant as a listing agent. When you have an unrepresented buyer, I talked about no representation agreements, or you can enter into limited service agreements and customize that per property. Or, hey, if you make an offer within the next week, I'm going to help you with the offer. I'm going to do this. I'm going to do that. Here's what I'm not going to do. Here's the compensation owed, if any. While these requirements are, they kind of put you in a tough position. They're very restrictive. There is a lot of room for creativity and customization as far as kind of setting yourself apart from others in the industry and also making sure that you are protecting yourself to the fullest extent you can. Now, one thing that comes up in this conversation is, let's say the seller or the listing agent isn't offering to pay any of my compensation, or they're only paying a portion, and I don't want to agree to take less. I want the full amount. That has to come out of the buyer's pocket. How do you enforce that? So as it stands right now, and we may see changes from lenders and things like that, but as it stands right now, if the buyer is paying your compensation directly out of their pocket, that is not a closing cost of the transaction. That is not on the settlement statement. That is not paid out at closing. So you essentially are in a private agreement now with your buyer to pay you a certain amount in exchange for services provided. And if the buyer does not pay it, you're in a position now where you can sue them to enforce the agreement. Not ideal for you guys because you're putting in all of the work on the front end. I also see the issue becoming more frequent as far as buyers saying, well, you said you were going to do all these things and you didn't do those couple of things, so I'm not going to pay you all of it. Or you promised to do X and you didn't do it, or you didn't do a good job. I'm not happy with your service. It's going to kind of open the door for all of those types of issues because it's not something that's going to be paid out of closing proceeds automatically, essentially. Yes, sir.
You're saying none of the commission, seller or buyer side, is going to be on the closing statement?
No, if the seller, so the listing commission will still be on the settlement statement. If the seller is paying the buyer's agent commission, that will be on the settlement statement. The only scenario where it won't is if the buyer is paying the buyer's agent directly. That's outside of the closing and it's not a closing cost.
Venmo.
I mean, that's an option. The question was, do they pay by Venmo? Like, that's an option.
So, and that goes to broker, right?
Correct.
That's also.
So it'll be an agreement between the broker and the buyer. That's owed to the broker, and then it would work just like this.
Yeah. In terms of, same day funding, time frame that we would be writing into these contracts. or max-
So, yeah, so,
Again, I didn't hear that.
so the question is, what are we looking as far as same day funding or timeframes for the buyer to pay this amount to you if they're paying you directly? So that is something that would need to be in the buyer broker agreement. When is this due? When is it late? What happens if it's late? Do you have any sort of penalty if it's late?
Yeah, and how are we determining that? I mean, is it coming to the agent and then we are a broker or?
So the buyer broker agreement is going to be between broker and buyer. So the funds, I mean, it's up to your broker, but I would imagine the funds still go to the broker and then whatever your relationship or split is. Correct. Correct. So I don't, this may be wishful thinking, but if the like FREC or Florida Realtors, if they have some sort of like dispute resolution procedure for this, I think that would be extremely helpful, because as an agent, 9 times out of 10 or more, it's not going to make sense it's not going to make financial sense for you to sue your own client. And then from a business perspective, do you want to sue your own client and be known as like, well, this agent's going to sue you if they don't do their job, and then you decide not to pay them, So they have that for escrow disputes and other commission disputes. I would hope that they are working on something like that. I don't know if they are, but that is certainly a nightmare level issue. If your only recourse is to either go to arbitration, which I hope these new forms do not include arbitration, or file a civil lawsuit, because in reality, it's really not much of a remedy at all. And that comes from a litigator.
Same day to the broker, like when they close, and that they are supposed to be bringing a check to closing the broker.
So I'm not seeing any of this. I have not seen any of this be implemented yet. I have not worked on a deal where the buyer's paying their agent directly yet. Now, is that happening? I don't know. I typically only see the disasters. Once something goes wrong, then it hits my office. But I haven't seen this scenario play out yet. So that is to be determined. Any other questions? All right. All right, so one thing to think about, and kind of in the context of all of these changes in this new kind of climate we're going to be in, I think the key is going to be, standing out from other agents, kind of selling yourself to buyers and effectively communicating to them like what makes you different. So it also applies in representing sellers as well, because that conversation might look different now, because you don't know what a buyer's agent is owed. You can decide we're going to offer the buyer agent X%, but maybe they've agreed to a higher percentage with their buyer and they're not willing to take less. So there's a lot of unknowns now on the listing side when you're having that initial appointment with your client. So something I just think is interesting to think about, should cooperating commissions be pre-negotiated with the seller when you're signing that listing agreement? And I think there's some kind of compelling reasons not to negotiate it up front. Obviously, we know it can't be advertised on the MLS, but you can advertise it on other websites and in other forms. If you pre-negotiate the cooperating commission amount, that number may be wholly irrelevant. You're going to be getting an offer from a buyer, if they're represented, who has already negotiated and agreed upon in writing what they're going to pay their agent. And that may be wholly irrelevant to the conversation you're having with your seller if you're agreeing upfront in the listing agreement what that compensation is going to be. So you may want to consider having a conversation with your seller that goes something like this. My fee or my compensation is going to be X% or X hourly rate, or however you choose to charge. So let's just use 3% to make it easy. At the end of this transaction, you're going to owe me 3% in exchange for the duties I owe to you and the services I'm going to provide. All I need you to sign off on and agree to right now is 3%. However, I want to prepare you that any offer we get from a buyer is likely going to include a request for us to pay at least a portion of the buyer's agent's commission. I encourage you to be open-minded to that. I encourage you to consider each offer on a case-by-case basis. But right now, today, all I need you to commit to is 3%. Because I do think one of the unfortunate effects of all of this is we're going to see an increasing number of buyer's agents working for a lot less than they historically have. I don't think that's going to be the permanent result. But in the short term, I think we're going to have some agents panicking and agreeing to lower compensation amounts than they have in the past or than they otherwise would in order to remain competitive. So that's something you're going to be dealing with. As for the seller, I do think it still makes sense to offer compensation to a buyer's agent, but pre-negotiating that number may do more harm than good on the front end. So any thoughts or comments, questions on that? That's not anywhere in the settlement or in the law. It's just a thought that I had and kind of practically seeing how this is going to all play out.
But yeah, I think so, but then are we seeing a lender impact with this, down here, and unless they're closing costs, saving funds, nobody needs to vet or verify what's coming in and out of that buyer contract, it's not gonna shake out in that settlement statement, the same.
So the lender's going to have to know what if the buyer is paying the buyer broker out of pocket directly outside of closing, while that won't be, at least as the case is right now, while that won't be a line item on the settlement statement, the lender's still going to have to know that for purposes of the loan and seeing where buyers' funds are going. So I'm not sure how lenders are going to handle that exactly yet, but they're going to want to know that amount if it's being paid directly. Yeah.
Wouldn't it be on the other side of your last comment of, less of an incentive to bring buyers and buyers agents to a property that is not advertising or committed to some sort of professional compensation with their listings, like, so I think that would be the impact. The other side of that for a seller to not advertise, where they could potentially bite themselves in the rear by not advertising anything, and fewer people are going to naturally want to show that property. If I know that there's a potential house that could be 3%, and it's not me, I'm just saying a lot of people do that, where this was supposed to make it transparent. And this made it the most convoluted mess in the world, because before, everybody kind of knew it's 2.5%, it's 2%, it's 3%, it was whatever. Now, it's throw confetti in the air and hope it lands, right? So now you have a house that is probably a nice house, could work out great. There is no professional compensation offered. That would potentially make a buyer not even want to look at it, because now they're on the hook for that 3% that they signed, that they were hoping to never have to pay. Less traffic for the seller. I don't know. I mean, I guess that would be.
I definitely think that is one of the most compelling reasons why it still makes sense for a seller to offer compensation. Because while you as the agent obviously can't make this decision, the buyer can say, I don't even want to see properties if they're not offering
They
compensation.
can afford to pay you. So
Or,
I
right.
have to make sure that I find a house that.
Sure. So I think it's going to limit your buyer pool. Additionally, even buyers who could afford it, that's liquid cash now coming out of their account versus maybe they pay a little bit more in purchase price that's financed, or, the numbers may make less sense for even a buyer that can afford to pay it. So my suggestion in all of this, if you're representing a seller, is be open-minded and look at the big picture of each offer that comes in, because you may have a buyer wanting you to pay their 3%, but they're offering $30,000 more on the purchase price. Or as long as your seller knows, this is net what I want to walk away with, that can be accomplished in so many different ways. That can include buyer compensation, that cannot include it. So, but that's definitely a very compelling reason, I think, for sellers to continue to offer. Yes, sir.
My understanding is that they're gonna have there's gonna be a broker to broker commission form. And there's also that old commission form that they're gonna update to where the sellers could possibly fill out that commission form, which is outside of the listing. So if a buyer's broker called up and said, hey, are you offering commission? Send me over the commission agreement, that would be written proof. But another thing that we haven't touched base with, I don't know what you're touch base with, not is the concession part. The seller concessions are still allowed on MLS. How it's defined is up to the buyer. not to, well, we're gonna use that money, the seller can dictate that we use that money for buyer's broker's fees, or the buyer's agent, the broker should not dictate that.
Correct. So seller's concessions is one way that a buyer's agent can be compensated. And that can be put on MLS as long as it's not defined in that way. It's just a seller concession. So that is one option here as well.
Just like thinking out loud, if you are doing the agreement, I mean, because on a 400, K house, 2.5%, that's $10,000 out of the buyer's pocket. So if they know that they're not gonna be able to do that, like, how does that, like, could you write in the agreement if the seller agrees in concessions, or if it's offered in like offer price, could you write it in that way that it's not coming out of the buyers?
So you cannot, in your buyer broker agreement, you cannot base the amount of compensation owed on a future unknown event, which would be that. So a future unknown event is what concessions a seller may be offering on a particular property you may become interested in. So for a buyer that wants representation, but that cannot afford to pay out of pocket, that buyer has to make a decision. Do I want to have representation, but limit myself only to properties where there's compensation in like sufficient compensation being offered? Or do I want to risk going without representation so I can make an offer? It's not
How
a
would they
great.
do that if, like, I just want to see properties that the seller's offering. That's very open-ended, like you said, we can't really do. So how do we dictate that?
So the buyer can tell you that. Here's my criteria. I need 3 bedrooms, 2 bathrooms, and I need properties where the seller's paying at least 3% or whatever they've agreed with you. And you can filter that through in the properties that you send to your buyer. So your agreement with the buyer is still objectively defined, 3%.
You can't, because it's not gonna list it. You'd have to physically call.
Correct.
So
Correct.
we can't see
So yeah, you
any-
can't set up like the auto things where it sends your buyer the properties, correct? Now, you can set up that auto generated like email that sends the properties and the criteria. And then if the buyer's interested in any of them, then you say, okay, now I have to go check and see if these properties are offering commission. You get your answer to the buyer, and then it's up to the buyer whether they want to see it or not. Yes, ma'am.
Maybe answer this. The buyer is not to be represented.
The listing agent would have to.
So to drive by like, oh, they criticize, right now, never.
No, they're just gonna stand in front of it and all them.
I mean,
They're standing there
Yeah,
and then I want to come inside the house.
yeah.
And then
so
the house is like crazy.
I'll kind of jump ahead to the bottom part of this slide, because we're talking about it, but I do think at least in the short term, we're going to see more buyers and sellers going unrepresented. I think that's going to be a result of the misinformation about the new practice changes, being spread throughout social media and through the media outlets. And I think that's going to be, as you all already know, a disaster. I think we're going to see buyers hire attorneys in lieu of an agent. I also think that's going to be a disaster as an attorney, because as you all know, I'm not showing properties. I'm not answering my cell on Saturday at 8 p.m. I'm not doing it. I will prepare a really solid contract, but aside from that, and that's something that as an attorney, I would explain to the buyer, like, here's what I will do for you. Here's what I'm not going to do for you. I always advise an agent and as an attorney, ideally on every transaction. But I think we're going to see an increase in unrepresented buyers, which is going to equal an increase in disputes and potential litigation, which is another big reason I think sellers should consider compensating buyer agents, because that protects themselves. It allows them to keep their agent as a fiduciary if you're in that single agent role, and it ensures adequate representation so that you're avoiding disasters down the line or after closing, which we all know. I mean, those things happen with agents. Imagine people not having any sort of expertise behind them. Yes, ma'am.
And a buyer decides that, you know what, I don't have the money, I'm not going to pay the agent, and go straight to the listing agent. The listing agent asks the buyer, do you have an agreement? They say no, but they end up having a buyer's broker agreement with another agent. How does the listing agent?
So the buyer has a buyer broker agreement with an agent, but they contact the listing agent directly and says, I don't have an agreement. So the buyer, the listing agent in that scenario showing the property has done nothing wrong, because they're entitled to rely on what the buyer's saying. The buyer is still obligated under that buyer broker agreement. So that if that's an exclusive buyer broker agreement, meaning if you go under contract during this time period, I don't care if I've showed you the house, you owe me my compensation, they would still be on the hook for that.
The agent can't come back with
That I did send them.
No, you're gonna sue the buyer.
This
No,
property.
you're going for the buyer. You have to sue the buyer. And that one's
So your only contractual agreement is with the buyer. So now, and I guess it kind of too depends on the timing. So if you find out that the buyer's gone under contract but hasn't closed and there was cooperating compensation, it's a conversation with the listing agent, but at that point, once the contract is signed, there's no, and this goes back to the first point I made, is there's no offer of compensation on the MLS anymore as of August 17th. So you now don't have a binding agreement between buyer broker and listing broker, because that offer of compensation, that acceptance and that formation of enforceable agreement is no longer there. So your recourse at that point would be to go after the buyer directly. Yes, sir.
Do you see the transition from the norm as being a transaction broker to single agent on the seller side? Do you see that shifting?
I mean, I don't know. So one thought I have is we're going to see more transaction brokers because we're going to see more buyers wanting to go unrepresented. And then they're going to approach the listing agent directly. And that listing agent either is already transaction or has the authority to convert to transaction broker. And so even if they're not receiving compensation from the buyer directly, they can still be a transaction broker as far as the duties owed. They're just not going to make, I mean, they're going to make the full listing amount. They're not going to obviously share in any of that. But I don't know. I find it very like specific to the broker. Some hate single agency, some love it, you know, some prohibit their agents from doing single agency. So I don't know if we're going to see a shift in that kind of thought process, but I do think buyers are going to think they can do it on their own and quickly learn they can't do it on their own. And then they're, you know, so it'll be interesting. Yes, sir.
The buyer broker agreement, can we have it where it says 3% if it's a resale home and 4% if it's new construction?
Yes. Yeah.
So that's all.
So that's a way that you can, because that's objective. It's either a new construction or it's a resale, and the buyer would know that up front. Yep.
That would solve the problem with the bonus commission.
Correct. And then if you're not getting a bonus, you can always agree just to take the 3% on the new construction if you want to. Yeah.
I'm gonna go back to what Chris was saying, about the state agreement. Like you were saying that Chris was saying that they don't offer
Mhm.
Let's say we have a listing agreement and have 2% on our listing agreement for the buyers. But let's say that someone brings a buyer and they have a 3% agreement signed. Can I amend my original listing agreement if that's all negotiation for what the purchase price is and what the seller's netting? I can amend my original listing agreement and then put 3% on that.
Yes. Yes. So we don't have these restrictions on the listing agreement side, just on the buyer broker agreement side. Yes, ma'am.
Make it better for the public. Serving Americans.
if a buyer then goes straight to the agent, and the listing agent also have a buyer broker agreement to be paid by both. Because otherwise-
Yes, so long as their listing agreement allows them to do that. So they're bound first by that listing agreement because that's already going to have been executed. So if that allows them to serve as transaction broker or to represent a buyer, then yes, they could collect separately from the buyer. All right, quickly on VA buyers. So we just recently got some clarity on this issue, although it's temporary clarity. But the VA has temporarily lifted their ban prohibiting VA buyers from directly compensating their own agents. So now, at least temporarily, I don't know what their plans are, but this is the exact language. I just copy and pasted into here. So VA buyers for the time being are going to be treated just like every other buyer where they can directly pay their own agents. Affordability, of course, is still an issue, but at least they have that ability, whereas before they were prohibited from paying their own. So that put them in a very sticky situation. All right, so we already kind of talked about this, strong incentive for seller or the listing broker to pay cooperating commission. We talked about protection from lawsuits. We talked about increased visibility for properties. And then we also talked about if you're in that single agency role for the seller, that's very valuable for your seller to have you stay on as a fiduciary to them and not kind of become more of a neutral and split duties between buyer and seller. You all know this, but quick word on steering. Buyers can steer themselves to properties that offer cooperating compensation. You as the agent cannot do that. So if that is your instruction from your buyer, you need to make sure that that's in writing, whether that's in your buyer broker agreement or whether that's just in an email. You need to make sure that you get that in writing from your buyer because that is a big ethical no-no. So make sure you're covering yourself in that way. All right, so what happens next? I do anticipate us getting some new standard documents in April. Florida Realtors said they would have them out in a few weeks. I think it's been a few weeks, but we still don't have them. So hopefully those will be coming out soon, and I would imagine prior to August 17th. So again, I'm hoping they've committed to a new buyer broker agreement, a new listing agreement, and other compensation agreements. I'm hoping we also get either a revision to the purchase and sale agreement or some agreement between seller and listing broker in those cases where the seller is going to be paying, or I'm sorry, seller and buyer broker. In those cases where the seller is going to be paying buyer broker directly and the listing broker is not going to be doing that. If you haven't already, start kind of processing and thinking about different compensation structures that may work for you in your business. Maybe that's the traditional percentage of purchase price. Maybe that's something else. But now's the time to really start thinking about it and figuring it out because these changes are coming whether we like them or not. If you do have any social media posts, flyers, mailers, advertisements, advertising your services as a buyer agent as free to your buyer, those need to come down immediately if they haven't come down already. All right, amount of compensation to buyer's agent should be included in the purchase and sale agreement. So again, until we get these revised documents, that can be added into the closing cost, paragraph 9 that was mentioned earlier, or the additional terms. Check with your broker for specific language to be used. As agents, you should not be drafting your own language in that regard. So get with an attorney or get with your broker on standard language for that. Consider treating your consultations with buyers like listing appointments. I do think that one of the intended results that we are going to see from these lawsuits is I do think it is going to become a lot more competitive for buyer agents. Part of that, I think, is due to the misinformation, like I can do this without an agent. Agents just open doors, like I got this. Or I just need an attorney to do the contract and like, I don't need anything else. I think that's a common misconception that's out there right now. So prepare yourselves, be prepared to discuss all of these uncomfortable issues and discussions that you're going to need to have with your buyers. What are the pros and cons of using an agent? What are the pros and cons of going unrepresented? Maybe you want to use an attorney. What are the pros and cons of using an attorney and not an agent? Address all of those issues head on, because I think, and as a real estate attorney, I think all of those conversations work out in favor of hiring an agent. I really do. 90+% of my practice is filing and defending lawsuits in connection with real estate transactions. And we see a lot of them, but we would see 10 times more at least if agents were not involved. Yes, ma'am.
If I have a client that says, what is the fee for an attorney? What is the fee for the contract? And I realize what that includes, non-inspections and all of that, but that's the contract side.
Sure. So we're actually working on, so for just the contract, which is not a service I think most buyers want and need, we would charge a flat fee of $500. If that contract does not make it to closing, are they still paying me? Yes. If that offer is not accepted and they need a new offer written, are they paying me again? Yes. So that's kind of something to discuss, but we're working on in my firm, because most buyers call in and say like, I just need the contract, but then they're calling me like, do you have an inspector? Oh my God, they found this. Like, I don't think they got this permitted. What do I do? And they're calling and asking for a lot more service than they've retained us for. Correct. So we are trying to work on like pricing out different packages for them. But none of those packages are going to kind of be all inclusive as far as what an agent would provide. I mean, part of my practice is all phone calls with me are pre-scheduled so that I can prepare and have it, I'm not answering my cell phone. You're not even getting my cell phone number. So those are conversations we're certainly going to have, but my office kind of rolls their eyes a little bit when people call in and say, I just want the contract, like I got everything else covered, because we know that's typically not the case. So we're updating our pricing to kind of include like reviewing closing packages, reviewing inspections, advising on how to fill out seller disclosures or how to review those sorts of things. But certainly not going to include, showings and things like that. Other questions, comments?
There was one, I'm a lender in the purchase sales agreement. One of the things I was looking at, you just put out is if it is in the contract that they're paying the buyer's agent, and it's specified in there that that's for their commission for the agreement, that won't go towards their seller concessions. Their limits to 3 to 4, 6%.
Yes. Yeah. Did everybody hear that? So the limits on concessions from a lending perspective, if that seller concession is going toward paying the buyer's agent, that's not going to count against their limit. Did I summarize that right?
Correct. As long as it's specified in the contract, that was.
I heard that is not correct yet for VA, but.
This only fading that.
Not for VA yet. So the only change I've seen come out of VA is that VA buyers can now pay their agents directly. I haven't seen anything about kind of not counting that as toward the limit on seller concessions.
Yeah.
All right, so you have me for another like 45, 50 minutes, whatever it is. So I'm happy to answer questions on this. Anything else real estate related? Yeah.
So right now, obviously, it's a tight market and are alongside transactions like that. This is on August 17th, but I anticipate a lot of agents on the road and utilizing these contracts. Who is going to regulate this besides realtors essentially looking point on each other, not comes in, the buyer broker agreement dated like out the show? How will this be used?
Sure. So enforceability, I think, is going to be an issue. Officially, the MLSs are enforcing it. What mechanism they're going to put in place to do that, I don't know. My guess is it's going to be based on a complaint process, just like we see with the ethics complaint process. It's going to be agents kind of whistleblowing on other agents in their transactions that aren't following these, which I do think we're going to see. Again, I think competition is going to go up. I think we're going to see a lot of stuff happening. I think we're going to see people take a lot of leeway with some of these rules. Other agents aren't going to like that they have to follow the rules and someone else isn't. So, but unless there's a complaint, I don't see how they could possibly put in, random audits. The life of a transaction isn't all that long. I just don't see how else they would do it, but definitely something we're going to keep an eye on. Yeah.
This contract is signed with the buyer, right? Which I've been doing it for a while, because I've been working with you for a long time, and I'm sure the importance of it, but if the seller doesn't see it, the seller's agent doesn't see it, who is seeing? And I guess that's kind of where my question is coming from. If we, like you said, if they ask for it, we're only sharing the compensation portion of the contract. Who's seeing this document?
Really the rights is with the buyer, is with the consumer. So if the listing agent is not seeing it, they obviously can't initiate a complaint because they don't know. It would really be the buyer's right to enforce if their agreement didn't conform with these. And where you're going to see that is a buyer that thinks you didn't do your job the way the buyer thought you were going to do your job. They don't want to pay you the full amount. You're saying, I don't care, you owe me the full amount. And then they're going to say, oh, it looks like there's this rule you didn't follow about my buyer broker agreement. And that's kind of, so I think in the midst of disputes and I do think we're going to see buyers trying to, at the end of a deal, renegotiate and say, well, we agreed on this. I have to pay the full 3% to you, but you know, you only showed me one house. You didn't do all these things you said you were gonna do. I could have got a better deal without you. Like, they're just gonna come up with these things and say like, I'll pay you 2%, but I'm not gonna pay 3%. And that's where I think we're gonna see buyers taking a closer look at, or calling attorneys and say, hey, can you find a technicality to get me out of this contract? That's like half my job right now. Not with buyer broker agreements, usually with the purchase contract, like, you know, so I think that's where we're gonna see it.
So from a listing perspective, as a listing agent, ask, get an offer, and they're asking for that commission, compensation in the contract. At that point, we can ask them for a copy of their buyer broker agreement, and we should only be requiring that commission portion of the obligation, is that right?
As the listing agent,
As a listing agent, like you're the buyer's agent, you're coming to me, you say my seller wants 3%.
so it's going to be up to essentially the listing agent, if they're paying, or the seller, what they're going to require in order to agree with whatever the buyer is requesting. So if it's your policy as the listing agent, or it's your broker's policy, like we need the entire unredacted buyer broker agreement, that's your prerogative to do. You might have a buyer walk that doesn't want to provide that, but so it's really up to you and your broker what you want to require, and your seller, what you want to require as far as proof or documentation before you're willing to agree to pay anything.
So super hypothetical here, but you're saying get creative. So what if you say, okay, the first 5 houses, I'm gonna get my, you know, pay this much. If I were to do a contract, it's gonna be this. Like, we could do like an a la carte, because then if they don't want to be represented and pay the whole 3%, I can kind of line item.
Yes, and I'm actually
them.
seeing, I've had several brokers reach out to me to create kind of like a la carte, because you're going to have buyers now, since they're maybe paying out of pocket,
Right.
they're gonna care a lot more about that
Right.
amount and are gonna try to negotiate a lot more. So I've had.
Like contracts and like.
Right, exactly. So I've had brokers come up with like, a la carte is a little bit aggressive because
Yeah.
it's like, you know,
Right.
but different like levels of services. So like if you want full service, that's like gold level and you're gonna pay this amount. If you just want the basics, here's what that includes. It includes nothing else, and kind of levels of service. I'm seeing that, yes.
Well, it's in that, if there's a menu of services and things, would you almost ask for the buyer, let's say like $5,000 up front, put in an escrow account, so then it can be deducted, because can you imagine writing, let's say, a span of 2 months, I showed 42 houses, and they went with the for sale by owner, but can you imagine, once they're done with you, I know, this is, I was burned, I'm still bitter about it, but imagine. But then, you know, then they go MIA on you, and then you didn't get paid. So it's almost like, I feel like if you collect something up front and then have it deducted out of an account, and then they take off, at least you can refund them the rest of it, but.
Sure. So when we have buyers who are going to be compensating you out of pocket, we talked about what happens if they don't pay. You get to go file a lawsuit, you know. We all know the finances of that, and maybe the implications of suing your own client and kind of getting into the habit of doing that. Not ideal on either front. So requiring a retainer up front will definitely protect you in that. However, you may have buyers that, you know, so I think with all of this, as a buyer's agent, I think the best way to go about it is kind of deciding like, what is going to work for me? What am I going to require? Like, what are my standards? And like not deviating. So you're going to have agents always that are going to be willing to do it for less. Like you can never be the lowest price. And that's with any profession, right? So you're going to have to kind of be more okay and feel more comfortable with buyers walking and saying like, no, this is not a good fit for me. Because if you're not, you're going to kind of be racing to the bottom of compensation levels. And I mean, I've seen like flat fee $5,000. I've seen flat fee $2,500. Like I've seen for, you know, pretty expensive type homes. So I think you just need to decide up front, like how you're going to structure your business and your compensation. And then it is what it is. Here's the benefit I'm going to provide you. And here's why it's worth it for you to sign with me. Here's what makes me different. And this is why I'm worth what I'm asking you for. It's the same old, you know, you get what you pay for type argument, but you're gonna have to be able to effectively communicate that and sell yourself. I mean, you're in the business of sales and it's really going to be exacerbated, I think, now on the buyer side. Yes, ma'am.
Then with, buyers with the protected capital, found recommendation of. Documentation and notes and everything and provided them to you.
Yep. Yep. Keeping, for those of you who couldn't hear, keeping meticulous notes and documentation of the services you're actually providing, because now if you have a buyer at the end of it that says, well, I don't think you did your job, you didn't follow the contract, the buyer may sue you. Or, I mean, if you want to consider suing your buyer, you're going to have to prove that with evidence in court. And so while you hope to never get there, knowing that you have it may prevent a lawsuit altogether, because you can show your buyer, here's everything I did, so kind of coming up with a system to manage that and maintain all of that, I think would definitely be a good idea.
So on open house going forward after this, there's a lot of buyers on weekends go without the renters to say, I have a rib. As the person, the listing broker, don't allow that person on the property until you're presented.
No, so long as you are only providing access to the home and answering general questions about the property, you are not required to have an agreement with that buyer. So you don't have, you can require proof of a buyer broker agreement to let them in if you want to, but you don't have to. You just have to make sure that you're not crossing that line of working with a buyer, because now you have no agreement with that buyer.
Well, a lot of listing agents who are heavily listing, don't, particularly like working with buyers and showing up. Do you anticipate that there'll be a buyer broker agreement that some listing agents won't work with when showing just that one listing or own listing right there at grant access, where the buyer can get out after that, or it's not blocking the long term?
Yes. Yeah. So I do think, and I think there's even like a showing agreement that's out right now, but I do think we're going to see a wide range of services provided. And I mean, you can even have, we talked about this a little bit earlier, but you can even have, as a listing agent, you can have an agreement with a buyer where they don't pay you anything, but you're just specifically defining, like, here's what I'm going to do. Here's what I'm not going to do. Here's what I'm going to do for my seller and the duties I owe to my seller, just so that it's clear, because I think we're going to see a lot more litigation coming up. So like, even if you're not required to have a signed document with a buyer, you might want to, even if it's a no representation or just some very limited form, either in substance or in time frame, just to make sure you're covering yourself.
You think that poses a problem long-term? Like, obviously, when you prepare a listing seller, a lot of times agents are advised to sell and acting as that. You see that be more prevalent now, especially with these kind of limited agreements because of how it works.
So yes, and that's just because I think too, like, issues and disputes in general are going to become more prevalent, at least in the short term, I think. But yeah, so I think those lines are going to be very blurred, because buyers, your typical or average buyer who's not a real estate professional, like, they have in their mind what they think an agent is going to do and provide, but like, they don't know, they have no clue. So without having a clear writing, I do think there's going to be issues there. And even sellers don't understand, if you're starting out as single agent, but you have that consent to transition to transaction, like, they don't understand, like, you're not still looking out for my interests. Like, I have no say, and you just all of a sudden like flipping to a neutral. So I do think we're going to see that happen a lot more as well. So I think the key is just like documenting everything you can in an agreement so that you're protecting yourself.
Have a sign, broker buyer agreement. New construction, sales. Are builders going to be required to also adhere to that? So I'll give you an example of why I'm asking. I had a family, I've done multiple deals with them, they wandered into a NAR on a Sunday because a new community opened right by their house, they had no intention to buy. Several months later, they considered, I was back with them, I was told I couldn't represent them because they had wandered in several months before. So in the event that was to occur again, we have a buyer broker agreement. They could wander in without me because they're running on Sunday. Would that still apply in that case? Because NAR's policy is if your agent isn't with you on your first visit, you cannot do that.
So in this case, Lennar would not be bound by your agreement. Your buyer would still be bound to pay you potentially if that's what your buyer broker agreement provided. But Lennar is not a signatory to that agreement, so they can follow whatever policy they want to follow. They have no obligation to honor that. Now, will they start honoring them given this new change? Will builders in general? I don't know, but legally they don't have to. But then you're gonna show your clients less Lennar homes if they're, you know, I mean, maybe.
So I have a buyer broker agreement for 3%. They go to work and then their coworker says, oh my God, my sister would do it for 2%. And then they just ghost me. I mean, and they go with they can go somewhere else and like.
You can too.
Well, so it depends on what your buyer broker agreement provides. Some of them provide that, but then they have that protection period. If you close on a home or go under contract on a home within X number of days, I still get my commission. So it's going to be wholly based on what your agreement says, whether they can terminate and whether they still owe you commission, even if they close with somebody else, given those circumstances. But then, of course, it's up to you to enforce that as well. Any other questions?
How fair do you see this for the buyer in this scenario?
How fair? So I don't know that the federal government's all in agreement with it, but so I definitely think it's a positive change to require buyer broker agreements. I understand they're not commonly used now, or they weren't in the past. I think that's a good change. As far as kind of hiding what the listing broker is offering, I think that complicates things a lot more, ultimately to the detriment of the consumer. And then I think a lot of these restrictions on you as agents now, and the restrictions specifically related to the buyer broker agreement, is going to result in buyers, you know, feeling like maybe it's best for me to represent myself, which I do think is going to be terrible for the consumer. So I like the little piece of it that requires a buyer broker agreement. I always think getting things in writing is best, but for the rest of it, and I mean, maybe it works itself out, like it's, you know, chaotic for a certain period of time, and then we all kind of get used to the new status quo and it works itself out. But and maybe like not a ton changes. Maybe listing brokers still continue to pay buyer brokers in the vast majority of cases, and a lot of what we're talking about right now is irrelevant because buyers aren't actually going to have to pay agents out of pocket. So we'll kind of just have to see how like practically it all works out. But I don't love the changes with the exception of requiring an agreement.
And the people that have money don't want to spend it, and there's more that don't have any money to even buy.
So that's what I think is the biggest. Yeah, people are gonna have to buy lower value homes so that they can afford the increased costs, and, you know, apparent in doing that.
Right now with, obviously it being transitioning more to a buyer's market, there's not as many homes selling, interest rates are high, not that much activity. I foresee like a lot of sellers still offering compensation. But as soon as rates drop, a lot of people on the fence will want to move up, but don't want to, you know, take that plunge because of go out to the 3% rate, they don't want to jump to 7, but if that comes down to 5, they might make the leap. Once that transitions, and it might not get a hot of a market as COVID was, or it gets into a much more aggressive market, do you foresee it then becoming the norm where buyers just pay the compensation of buyer's agent? Because if you get this competitive offer again, as it was then, where the waiting inspection contingencies, overpaying $20,000-$50,000 on a house. And I'm assuming most of those offers will come to buyers paying the buyer agent commissions themselves. Because if it's a concession, if you're in a multiple offer situation, that concession might lose the offer.
Yeah, I mean, it's really hard for me to say right now. I do think in a hotter market, you'll see more of that because buyers have the ability to do that. But I still think in a hot market, it's still beneficial for the seller to offer that cooperating compensation, because the deal can be worked out where they're netting the same exact thing, you know. So I don't know that we're going to see a huge change even in a hot market like that. Now, we saw some crazy stuff over COVID that I didn't anticipate us seeing. So, you know, so maybe we do, but I don't know. I still think it makes sense. And just kind of thinking of myself as a buyer and myself as a seller, like, I just still think it makes sense to do that. Regardless of the buyer's financial ability to cover it. So, and then of course, it's gonna be best for the agents as well. They get paid out of closing, like, you don't have to think about it. It's all just done automatically with the proceeds. So I don't know, that'll be something interesting to see. Correct, correct.
And you do a good deal with an agent, a listing agent, you're the buyer's agent, and you know that that listing agent has looked out for your best interest as well. In setting up that listing, you're gonna be inclined to show that agent.
Right.
That's kind of the value that I share with my sellers, even now, before this becomes about is when you set yourself apart as a good listing agent, easy to work with, fair, amicable, then agents want to do business with you.
Right.
So they're gonna come back and they're gonna go, oh, you're gonna borrow some statement. I'm gonna go ahead and get that off because I know they're not gonna help.
Yeah, I 100% agree. And I agree that, education is really going to be key because you're fighting all of the information they're hearing from their uncle and their coworkers at work and, social media and all that kind of stuff. So, I do think education is key. I think, on the buyer side, a lot of what I'm hearing is, well, the seller will reduce the price if they don't have to pay an agent on my side, which a lot of times that's not the case. You're not getting a deal or a discount on the property because so I think, being very well prepared to educate and again, addressing all of these issues head on is going to be key. Anything else? Well, thank you guys. Kelly from my office is here. She's going to be passing out my card that has my direct contact info on it. And then she has some flyers. We have a monthly subscription service that gets you access to consultations, template documents that I've drafted, lots of resources, lots of educational things like this. The first month's free, so you can use that QR code and check it out for free for the first 30 days. But I will be hanging around if you guys have any other questions as well. Thank you guys so much. I appreciate it. My cell phone is not on there. Excellent question.